Hi, this is Rob Herskovits. People call me on a regular basis, FAs who are considering leaving their current employer and joining a new brokerage firm. And one of the things that we'll often talk about is first whether or not the FA has any type of employment agreement with their current firm, because it's not unusual for broker dealers to ask employees to sign agreements that contain restrictions which would limit the person's ability to do certain things on a post-employment basis. But let me be specific about what I'm referring to there. Oftentimes you'll see either a non-compete clause, which could say that the FA is not entitled to work for a competitor for a certain period of time and within a certain geographic region. It could include a non-solicitation clause, which says that the FA is not entitled to request that customers of their former broker-dealer transfer to the new broker-dealer, and it could include a clause which suggests that the FA can't induce employees to join him or her at the new firm. So there's an important agreement of sorts that is utilized in the securities industry which directly impacts upon these types of restraints, and that's called the Protocol for Broker Recruiting. So the protocol was born out of a fairly simple problem. And historically what used to happen is if, for example, a team of FAs left Merrill Lynch and joined UBS, Merrill Lynch would sue them and would sue UBS, and then a settlement would be struck, and then the week after, a team of FAs would leave UBS and go to Merrill Lynch, and then the reverse would happen. Each firm was suing another and then getting sued by that same firm. And the brokerage firms found themselves writing checks and receiving checks, and I think they all sort of landed in a place of what's the point of all this? And so they reached an agreement called the Protocol for Broker Recruiting, and what that agreement says is that if the FA leaves a firm that is a signatory to the protocol and joins a firm that is a signatory to the protocol, so long as they resign in conformity with the protocol, that FA is free to solicit customers that he serviced at his former firm. Now, there's some important considerations here, and the first is that in order to invoke the protections of the protocol, you need to act in accordance with the protocol. So that would mean that you would need to resign in writing, you would need to resign to local branch management, and with the resignation, you would need to provide a client list which contains certain pieces of information that are set forth in the protocol, and that would be customer name, account title, phone number, email address, etc. And you're not permitted to take with you any sorts of documents or information that would be considered confidential or proprietary to the firm. The departing FA can take only essentially their resignation letter and the information that they are permitted to take under the protocol. So if an FA does in fact resign in conformity with the protocol, then the essence of that agreement is that they do so and do not have to fear litigation from their former firm. Unfortunately, I've seen instances in which FAs don't resign in conformity with the protocol or join a firm that's not a signatory to the protocol, and then of course they don't enjoy any of the protections of the protocol. Recently, though, I've seen an interesting dynamic as it relates to the protocol, that some firms are trying to, in essence, carve out certain employees from being able to invoke the protocol. Now, if a firm is going to play by the book, and if a firm wants to designate a certain group of employees as non-protocol employees, yet these people are financial advisors, then the firm would need to place some limitations on its agreement to be part of the protocol and notify other signatories to the protocol that, look, we're participating in this, but our participation is not absolute and there are limitations. But there are instances in which that type of notification does not go out, and firms seem to, as I said before, sort of carve out either FAs or groups of FAs on almost a one-off basis. That's a situation that would give rise to some litigation, and I'm not sure that the firms that do that are ultimately going to be successful in being able to carve out certain groups of FAs without having given notice to the other signatories to the protocol that they've done so. But the bottom line when it comes to resignation from a brokerage firm is to be exceptionally careful. There are distinctions between types of brokerage firms. There are the wirehouses, which generally adopt the position that the accounts of the financial advisor are in essence his or her accounts that were generated as a result of his or her activity. But there's a fundamental distinction between sort of the traditional wirehouse model and, say, the model that has been used for many years by a place like Fidelity. Fidelity would take the position that we spend tons of money on commercials and we have storefront, street-level office space, and when people open up an account at Fidelity, for example, they would likely argue, they do so because of the Fidelity name and not because of any given FA, and those accounts, they would say, are our accounts. And for that reason, Fidelity and firms like Fidelity will never join the protocol because they will essentially move heaven and earth. If an FA leaves and tries to take their accounts, they will instantly go to court and seek a temporary restraining order and initiate FINRA arbitration. So when an FA is considering leaving to join a new firm, there are a host of considerations ranging from the type of firm they work at, any employment agreements that they may have, and the manner in which they go about resigning. And those are some of the things that we do at my firm, and we certainly welcome calls from anyone who have questions about joining one firm or another. I appreciate you tuning in.